Can you repeat it?
Yeah, was there an accident? How did they catch up with you?
I just pulled over. I got home. I went home and just pulled over at 1529 New York Street.
I see. Okay. And you knew that you should have pulled over long before that, correct?
Yes, Your Honor. Yes.
And when you were fleeing from them, it's fair to say.
Right from the start, this courtroom heats up as Jason Quinn faces serious felony charges with a massive gap between a 5-year plea and a potential 15-year sentence. One decision could change everything. Will he play it safe or take the risk? Subscribe for more intense courtroom breakdowns like this one.
This is docket, are you ready, Nancy? Yeah. 25-5164FH, People of the State of Michigan versus Jason Quinn. Counsel, your appearance for the record.
Good morning, Your Honor. AP Bart Buxton on behalf of the people of the State of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Jason Quinn.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I swear.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had enough time to speak to your attorney?
Yes.
All right, counsel, what are we doing here today?
Your Honor, today is set for a final pre-trial. I have had a chance to discuss with both victims on this matter, this case. I actually was on the phone with both of them yesterday. The people have given an offer to an added count 3 of attempted assault to do great bodily harm, less than murder, or by strangulation. And we will be dismissing count 2. There will also be a kill rule agreement to no upfront jail at the time of sentencing. My understanding is that the defense is rejecting that plea offer and moving forward with trial at this point.
So it would be dismissing count 1 and 2.
Correct.
And an added count 3 and dismissing the habitual?
Correct, Your Honor.
Okay. Is that full, fair, accurate, and complete?
It is, Your Honor.
Sir, is that full, fair, accurate, and complete? The offer? Do you understand the offer?
Yes, ma'am.
All right.
As Mr. Quinn's asked, saying he wants to know, I think he still wants to think about the offer, doesn't want to take it today.
Well, today's final pretrial, final. We don't get all of that. So you can have, this morning you can go chat. Here's the deal, sir. Right now you have count 1, assault with intent to great bodily harm, less than murder by strangulation, which is a 10-year felony. Count 2, assault or assault and battery is a 93-day misdemeanor. You have a habitual offender second offense notice, which means that the primary offense, which is the 10-year, becomes, if convicted, a 15-year on the max. I don't know what your guidelines are. Maybe counsel has run them. What they're offering is to get rid of the 10-year, get rid of the 93-day, get rid of the habitual. So what you're left with is pleading to count 3, which is an attempted assault intent to great bodily harm, less than murder by strangulation, which now becomes an attempt as half. So half would be a 5-year. So a 5-year versus a 15-year, that's what you've got on the table. This is the final pretrial, and final means final. So go back and chat.
Yes, ma'am.
Next matter.
Nope, you good? No.
Are you gonna need another breakout room for your guy?
Probably, yeah.
Okay, I just moved him back into the main session, so I'll put him back.
All right, at this point in time, I don't have any other defense attorneys that I can move forward on at this point in time.
Mr. Foreman is on Zoom talking to Mr. Williams right now.
Understood.
Are you ready in the case?
No, Your Honor, we're kicking it down the line. Thank you.
Okay, do we have a new date?
Yeah, that was the Kane case that I.
Oh, the King one? Okay. And are you okay with that date?
I didn't get a date, I'm sorry. We
Oh, sorry, no, never mind. I'm
Yeah.
sorry, that is Coe and Nugent, they're set for status conferences today. We're just gonna be moving those setting them for a pre-trial in the next couple of weeks. That's a prosecutor Berman case, and he's not here right now, so I don't want to set a trial date that may conflict with his schedule.
Joe, have we had a pretrial and final pretrial?
We have not, Your Honor. These are cases that were moved over from the annex and they were up at the Michigan
Alright.
Supreme Court.
These take priority. These are a 22 case. This is ancient, probably ancient on my docket. So this is priority. So I don't know, I want trial dates by the end of today.
Understood, Your Honor.
This is, 4 years down? So, yeah,
As
these
a
are ancient.
practical matter, Judge, just so I know what kind of trial date, where you're looking, how far out. Just as an estimate.
What about the discovery? Do you
It's
have
been
the-
dragging so long, I think, well, Mr. Zaney and I are going upstairs shortly to meet with Mr. Dwayne.
Okay,
I think discovery is long complete.
okay,
But this just got transferred. Was on a stay to the Supreme Court for a while. So I'm just
okay.
curious for my own scheduling purposes, how far out are you thinking?
This year,
Okay.
does that make
I'm
sense?
fine with that.
Look at this year. It's not gonna be a 27 case. We're gonna bump cases. This is gonna be the #1 case, no matter where we put it. Is he in lockup?
No, neither of them are in lockup, Your Honor.
Okay, well, let's get a date before the end of the year. Is this gonna be a week or two?
At least.
Okay. So is this two,
There are two cases, Your Honor.
has this been consolidated? And will it be consolidated?
Came up consolidated. As I recall, I filed a motion to bifurcate or vice versa. So,
Okay,
candidate, I hate to sound unprepared, Judge. I was of the
it's
impression
okay.
we were kicking this today.
Well, we can kick it. We're not kicking it into 27, and if you need, I don't know what Kennedy did or didn't do. I tend to do something that's a little bit different than him, so if you need to re-bring motions, please do that. Set it all, let's get going.
Understood, Your Honor.
Great, by the end of the day, we're gonna have dates, or else I set them and won't move them. How's that?
Understood, Your Honor.
Thank you.
On the side.
Huh?
On the side note with these two.
While everybody gets organized. Oh, right here. All right, hold on. Yeah. Okay, we're back on the record on docket 25-5164 FH, People of the State of Michigan versus Jason Quinn. Sir, we had enough time to speak to the attorney?
Yes, ma'am.
Counsel, what are we doing here?
Yes, Your Honor, Mr. Quinn, you and I talked today about the plea offer, is that correct?
Yes, sir.
We also talked at our last hearing, just before that, about our plea offer, is that correct?
Yes, sir.
And earlier this morning, as well as before, you had rejected that offer, is that correct?
Yes, sir.
And you heard the offer communicated to you on the record earlier this morning, is that correct?
Yes, sir.
And I know you needed a moment to speak with me about that offer, is that correct?
Yes, sir.
And I went over and explained to you all your questions, is that correct?
Yes, sir.
And you decided to reject that offer, is that correct?
Yes, sir.
And you know that if you rejected this offer, not only is it revoked, but there will be no other offers on this case, is that correct?
Yes, sir.
And after hearing all that, what do you wish to do with regards to your case then?
Go to trial.
And no one's forced you to make that decision, is that correct?
I'm sorry.
Are you making this of your own free will, is that correct?
Yes.
This is your decision, is that correct?
Yes.
And no one's promised you anything?
Excuse me.
No one's promised you anything?
No, ma'am.
And you've been satisfied with the representation of your attorney?
Yes, ma'am.
And you made this decision after you talked with him and looked at all your options?
Yes, ma'am.
All right, do we have a trial date?
Yes, Your Honor, that trial date is in April, let me just double check that date. It is April 24th, Your Honor.
I don't know, I think we have several trials on that day, so I don't know where this will fall in line. So do we have a backup day?
We do not have a backup date at this time, Your Honor.
All right, keep in touch,
We
sir,
will.
with your attorney, because I'm not sure, be ready for April 24th, but I know in the last few weeks, they've set way too many things on April 24th, so I don't know that it's gonna go.
Okay.
Just depends on, especially since he's out of custody. It's a 25 case, but probably not the oldest one, so we'll see. But be ready to go then and just keep in touch with your attorney. Bond and bond conditions are continued, and sir, do you have everything you need for this trial?
I believe I have all the discovery, Your Honor, if not, I can get ahold of Mr. Bucks if I believe that.
All right, thank you, that's all for the record.
This is the turning point. Quinn officially rejects the plea deal after confirming multiple times it's his voluntary decision. Legally, that locks him into facing full charges at trial. The safety net is gone. Do you think he truly believes he can win? Or is this a gamble that could seriously backfire?
I don't have the bench warrant, so I can't proceed. This is docket 255462FH, People of the State of Michigan versus Michael David, is it Gramsa?
Grams.
Grams?
Yes, yes.
All right, thank you. And counsel, your appearance for the record?
Good morning, Your Honor. A.P. Bucks on behalf of the people of Michigan.
Good morning, Assistant Public Defender Sarah Donnelly on behalf of the defendant who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
Medication?
It's just a yes or no. I don't need to know why you take it.
Yes, Your Honor.
Is it anything that would interfere in your ability to understand the court or your attorney?
No, Your Honor.
Counsel, do you believe he's oriented to date, time, and place and does understand?
Yes.
All right. I do as well. He's got good body language, eye contact, he's able to answer questions. Is there medication you're supposed to be on that you're not on?
Yes.
And does that affect your ability to understand the court or your attorney? Any sign of fever, COVID, or other illness?
No, no.
And you've had enough time to speak with your attorney?
Yes.
And sir, it appears you are on bond conditions for count 1, retail fraud, first degree, a 5-year felony, count 2, police officer assaulting, obstructing, felony punishable by 2 years, count 3, police officer assaulting, resisting, felony punishable by 2 years, attempted police officer disarming, non-firearm, this is a misdemeanor, high court misdemeanor, punishable by 2 years. And with habitual offender second offense notice, that would be 1.5 times the primary offense, so that would be, the primary is 5 years, that'd be 7.5 years. And you were placed on bond conditions, remember that?
Yes, Your Honor.
And counsel, have you gone over the bench warrant?
Your Honor,
Do you have it? I didn't have it, I just,
you're right. I haven't confirmed whether I received it or not.
well, there was a contempt issued for failure to appear for pretrial with this court on December 3rd, 2025 at 9 a.m.
I have gone over the allegation, yes, with him.
Did you need a few more minutes with him?
No, Your Honor.
All right, will there be a plea or a hearing, and are you waiving further arraignment?
He's not disputing this allegation, though he does have an explanation.
And are you waiving further arraignment?
Yes.
All right, and sir, you understand the alleged violation?
Yes, Your Honor.
Failure to appear for a pretrial conference that was held on December 3rd, 2025 at 9 a.m. How do you plead?
Guilty?
Did anyone force, threaten, or coerce you to plead?
No.
Did anyone promise you anything that caused you to plead?
No, Your Honor.
You understood that under bond conditions, you were to appear for all hearings and proceedings, correct?
Yes, Your Honor.
And you failed to appear for this. I find defendant's plea has been freely, voluntarily, knowingly, and understanding made. He's admitted that he knew and understood and failed to appear. He is held in contempt. And we have, well, let's hear what, counsel, what happened.
Your Honor, he was at Bear River for a time. He was discharged unsuccessfully. He did not I did not get in contact with him after that, and so I didn't inform him of the December 3rd date, and when it came by and around, he did not appear.
Well, and I have a note here that he was discharged from Bear River for breaking rules.
That is the allegation, Your Honor.
Okay, that would be another bond violation, or was he under this? Was that under another file?
He was on probation at the time in front of Judge McKean.
Okay, and she dealt with that issue?
Yes,
What did she do?
time served.
Okay.
She's revoked probation.
Okay, how much time did you serve, sir?
At that point, I think it was 30 days is what she gave me.
Okay.
Now things shift. Another defendant admits to missing court, resulting in a contempt finding. That's huge because it shows how seriously judges treat compliance. Even with explanations, accountability comes first. It raises the question, are these defendants underestimating how strictly courts enforce rules, or just struggling to keep up?
Well, are we able to have a pretrial today?
Yes, Your Honor, we had the pretrial forms ready at the December 3rd date. At this moment, we will be ready to proceed with the pretrial, though. I want an opportunity, some time to talk to the prosecutor in regards to a possible sentencing agreement, only because he's now sitting in Eaton County Jail. Based on that information.
Eaton County Jail and more charges?
Yes.
What are those charges?
I'm not exact.
What part of the process are we in over there?
Larceny and resisting obstruction is my understanding.
Is this on bond conditions? Did he plead? Was he sentenced? What's the status?
We're waiting because they're trying to send me to SAI, like make sure I'm SAI eligible.
For boot camp?
Yes. So, in order to be SAI eligible, I can't have any pending felony charges. So they're trying to take care of the charges.
Okay, well, why don't y'all have a chat today? It doesn't seem that complicated to me.
Yes, Your Honor, that is hopefully it won't be too hard to work out some sort of plea offer. With Mr. Gramza, obviously, we have the offer, we've already had it. It's just them working on a sentencing agreement. So
go back and work on it.
I would need, obviously, if I can have Mr. Buxton, I can do that. That's who I need.
Okay. All right. I'll see you shortly. All right.
Thank you, Your Honor.
I mean, otherwise we're holding him up even further. I'm not interested in doing that.
I understand, Your Honor.
Thank you.
Thank you so much, Your Honor.
Did you get it?
I did.
It's not there. Pull it up.
Yes. It is. That is. That's why I don't have one. Still open up this right now.
I sent an email.
Just call the law clerk.
Okay.
Call.
Okay.
I think we're ready to go.
Okay, I need the file. This is picture.
No, this is Aubrey.
Aubrey. Okay, let's talk to Fisher. Okay, got it. All right, this is docket 2481FH. People of the State of Michigan versus Otis Aubrey. Counsel, your appearance for the record.
Good morning, Your Honor. APA Burt Buxton on behalf of the people of the State of Michigan.
And good morning, Your Honor. Stephen Mills on behalf of Mr. Aubrey. Mr. Aubrey is present with us via Zoom at this time, waiving his in-court appearance. He is appearing from Parnell, NDOC, Your Honor.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, Your Honor. Yesterday, just my regular medication.
That's fine. And is it anything that would interfere in your ability to understand the court or your attorney?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you've spoken to your attorney?
Yes, ma'am, Your Honor.
And you're in agreement that you are there and he's in the courtroom, you're not standing next to him, is that correct?
Yes, Your Honor.
So if, sir, at any time you want to speak to your attorney, that is your right, just let me know and we'll put you in a confidential breakout room. Is that okay with you?
Yes, Your Honor, it is.
All right, thank you. And sir, I understand that there's going to be a plea today, is that correct?
Yes, Your Honor.
All right. On behalf of the people, what is the plea agreement?
Yes, Your Honor, the plea agreement in this case would be for the defendant to plead to count 2, fleeing in the 4th degree. Upon successful plea and sentencing, count 1 and the habitual offender 4th status will be dismissed. In addition, Your Honor, there is a Killebrew agreement to no upfront jail at the time of sentencing. There will be restitution, but that'll be determined at the time of sentencing, Your Honor.
Full, fair, accurate, and complete, counsel?
Yes, Your Honor, that is.
Sir, is that full, fair, accurate, and complete?
Yes, Your Honor.
And what you're pleading to, were you on probation or parole at the time of the event?
No, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
Did you graduate high school or get your GED?
I'm taking my GED as we speak, Your Honor.
All right, good for you. All right, counsel, you're waiving reading count 1 and the habitual 4th offense notice in its entirety
We do waive that reading, Your Honor.
as to the added count 2.
Yes, Your Honor. People of the State of Michigan versus Othis LaPriest Aubrey, State of Michigan, County of Hingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about November 24th of 2023 at Vermont Avenue /1529 New York Avenue, City of Lansing, County of Hingham, the defendant in count 2, police officer fleeing 4th degree penal code, being the operator of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Officer Caitlin Miller, a police officer who was in uniform, and the officer's motor vehicle was identified as an official police motor vehicle, acting in the lawful performance of his or her duty, directing the defendant to bring his or her motor vehicle to a stop, did willfully fail to obey such direction by increasing the speed of the motor vehicle and or attempting to flee or elude the officer, contrary to statute. This is a felony that is punishable up to a maximum of 2 years and or $2,000. Secretary of State shall suspend operator or chauffeur's license for a vessel privileged to operate shall suspend for a period not to exceed 5 years. Court shall order law enforcement to collect DNA identification profiling sample before sentencing or disposition if not taken at arrest and against the peace and dignity of the State of Michigan.
Thank you. Sir, did you understand what was just read?
Yes, Your Honor, I did.
So you understand police officer fleeing on 4th degree is a felony punishable by 2 years and or $2,000. DNA would be taken if it's not already on file. I suspect that's on file, and you will be required to pay restitution for any personal or property damage. If you dispute the amount, your attorney will let me know. We'll have a hearing and I will determine the amount. The amount can go up, can go down, and your license may be suspended for up to 5 years. Do you understand all of that?
Yes, Your Honor.
And sir, looks like you signed the advice of rights form or gave your counsel permission to sign it on your behalf. Is that correct?
Yes, Your Honor.
Did you go over your rights with your attorney?
I did, Your Honor.
And he was able to answer any questions you may have had. Is that correct?
Yes, Your Honor.
Do you have any questions about your rights at this court?
No,
Here, Aubrey takes a very different path. accepting a plea deal to a lesser charge, avoiding harsher penalties, and habitual enhancements. The judge carefully confirms every right waived, locking the plea in. This decision trades uncertainty for control, but consequences remain, including possible restitution and license suspension tied to the offense.
Ma'am, Your Honor.
Sir, as to count 2, police officer fleeing 4th degree under the penal code, how do you plead?
Guilty.
And sir, you understand that by pleading, you are giving up certain rights and defenses you would have had you had a bench trial or jury trial, including the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to hold the people to their burden of beyond a reasonable doubt, etc. You understand all of that?
Yes, Your Honor, I do.
And you understand you can't come back here and say, Judge, I want to withdraw my plea because someone forced, threatened, or coerced me or promised me something. If something happened like that, you need to tell me that now. Do you understand?
Yes, Your Honor.
Have you pled of your own free will?
Yes, Your Honor.
And you did that after consulting with your attorney?
Yes, Your Honor.
And you've been satisfied with the representation of your attorney?
Yes, Your Honor. Yes.
All right, thank you. And sir, did this offense occur on or about November 24th, 2023?
Yes, Your Honor.
In the city of Lansing County, in the state of Michigan?
Yes, Your Honor.
At a specific location known as Vermont Avenue and 1529 New York Avenue?
Yes, Your Honor.
Were you the operator of a motor vehicle?
Yes, ma'am, I was, Your Honor.
And did you come in contact with law enforcement?
Yes, Your Honor, I did.
And that was in an official deputy or police car?
Yes, yes, Your Honor.
Did they give you a signal to pull over?
Yes, Your Honor. Siren.
Siren, and you understood that meant pull over now?
Yes, Your Honor.
And you failed to do that, is that correct?
Correct, Your Honor.
And did they eventually catch up with you?
Yes, Your Honor.
And was that because there was an accident, property damage, or something else?
Can you repeat it?
Yeah, was there an accident? How did they catch up with you?
I just pulled over. I got home. I went home and just pulled over at 1529 New York Street.
I see, okay. And you knew that you should have pulled over long before that, correct?
Yes, Your Honor. Yes.
And when you were fleeing from them, it's fair to say you went over the speed limit in an area that was 35 miles per hour or less, is that correct?
Your Honor, that's just in
Correct.
regards to.
Okay, all right. And I understand there may be restitution. What is the restitution from?
You know, I'm actually not certain the restitution will be from.
Your Honor, my understanding, based off of the reading of the police report, was that the defendant was kicking the police vehicle, so there may be some damage afterwards.
I see.
So.
Okay.
And I do not have that for sure, Your Honor, but that was written in the police report, so that's why I just wanted to make the court aware that there may be restitution.
All right, and sir, do you understand that if you violate the law between now and sentencing, I don't have to honor the no further upfront jail?
Yes, Your Honor.
But if I violate that and give you some more time, then I would allow you to withdraw the plea in this matter, but again, go to the pretrial stage. You understand all of that?
Yes, Your Honor, I do.
All right, on behalf of people, any additional questions?
People are satisfied, Your Honor.
Defense is also satisfied.
Thank you. Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule?
You have, Your Honor.
You have, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter, count 1 and the habitual offender fourth offense notice in its entirety are dismissed. Any outstanding warrants, if any related to this file, are also recalled and dismissed. Do we have a sentencing date?
May 13th at 10 a.m.
Does that meet with your schedule?
It does, Your Honor. Yes.
And so you'll do a writ at least for Zoom?
And I just wanted to clarify, Mr. Aubrey, are you still going to be in MDOC at that time?
Yes, ma'am.
All right, and do you still want to do it like this over Zoom, or would you like to be brought into the courtroom?
Whatever pleases the court, Your Honor.
It's not about me, it's about you you have a right to stand next to your attorney. If you would like to do that during sentencing, you may, otherwise we can do it like this as we did the plea. It's up to you, sir.
Oh, well, we can do it. We can do Zoom, Your Honor.
All right, great. We'll do it by Zoom.
I will get that set up, Your Honor.
All right, thank you. Sir, you'll need to cooperate with probation. They're going to do a very detailed pre-sentence investigation report that we'll all talk about at the time of sentencing. So your attorney will get with you before we get on the record and go over that with you, okay?
Yes, Your Honor.
All right, anything else for the record?
No, Your Honor, thank you.
Nothing from the defense. Thank you.
All right, have a good day. Thank you. That's all for this record.
You do the Ronnie Williams sentencing next?
Yes, ma'am.
Where is he?
He's on Zoom, Judge.
Oh.
In the end, we see two completely different strategies. Quinn risks trial with higher stakes, while Aubrey secures a controlled outcome through a plea. Both decisions carry consequences that will shape their futures in court. Which approach would you take? Like, comment, and subscribe for more powerful courtroom stories and breakdowns.